Today we're going to continue our discussion of sub-disciplines of economics. So as you'll recall, last week I mentioned that the first about 10 chapters we covered were designed to introduce you to the core of microeconomic theory. And since last week we've been discussing areas that we can apply this core theory to. So last week we discussed government, and this week we're also going to discuss government, but especially its application to two areas that are closely related. Antitrust policy, which in other parts of the world is called competition policy, and then regulation. We see in this startup a case about Visa and MasterCard, and both of these companies were found guilty of anti-competitive behavior. In other words, a violation of the antitrust laws. And in particular, they were excluding Discover and American Express. They were trying to exclude Discover and American Express from markets, and then they had to pay fines in the billions of dollars as a result. So we're going to talk about, in this first section, what's the history of these antitrust laws. And in general, in this whole chapter, we see almost no graphs. So it's a lot of factual information and history. I think you'll be happy that in the final exam you're able to use your book, because some of these facts are hard to memorize, or there's so many facts it's hard to memorize. But keep all these models and theory in the back of your mind, because we're going to be thinking about these problems through the lens of that theory. The history of antitrust laws in the United States goes back to the days after the Civil War, when the Industrial Revolution had really begun in earnest in the United States, and also in England and a few other countries. So the Industrial Revolution, by the way, is a very important historical event, and there are many different explanations for it. One is, for example, the substitution of human and animal power for fossil fuel power. But really we saw a dramatic increase in production and incomes and so on, starting around 1776, 1850, around there. But what we also saw was a few corporations, or trusts as they were known at the time, began to control large swaths of industry. So for example, the railroads were controlled by a few companies. Oil that began to be refined into gasoline starting around 1900, again controlled by a small number of these trusts. And so the concern was that they're so large, they're acting as monopolists, that they're going to basically be charging high prices, be bad for consumers, bad for society. And so these antitrust laws, as they're known, are designed to check that. The first law that the United States passed was called the Sherman Antitrust Act. And this was passed in 1890. And there are really two main parts to it. One is, which is called Section 1 of the Sherman Antitrust Act, laws that prohibit monopolization. And so these are activities that a firm might undertake in order to achieve a monopoly. So for example, there's something called predatory pricing, where you charge a price below your cost of production even, with the intention of driving your competitors out of business, and then once they're out of business, you raise your price again. And Standard Oil was charged with predatory pricing, among other things, and Standard Oil had control of about 90% of the country's refineries at that time. And they were the first company to which the Sherman Act, the laws under the Sherman Act were applied. So they were sued under the Sherman Act, under Section 1, attempts to monopolize an industry. And then there's Section 2, which deals with agreements between competitors, for example, to fix prices. And so we talked before about cartels and how if a cartel wants to maximize their joint profits, they would agree to set prices higher than they would otherwise be. And so this is also now illegal as of 1890. There's a distinction that is made here in the book and that you should be aware of between per se illegality and the rule of reason. And so what does this mean? Well, if something is illegal per se, it means it's illegal and there's no justification for doing it. So for example, the example here is shoplifting. There's no justification for shoplifting. If you do it, you're guilty. If you're found guilty of it, you're going to be punished. On the other hand, some things are, fall under the rule of reason. And I'll give you an example of this. There's something called resale price maintenance. And this is where a manufacturer who distributes their product through a network of retailers and tells the retailers, you can't charge below some price. And let me give you a more concrete example. Let's say we have Sony, and they produce Blu-ray players. And then they distribute them through retailers like Best Buy and Fry's, and so on. And they say, Sony says to Fry's and Best Buy, you can't charge less than, say, $100 for this. Now, on the surface, that seems anti-competitive, right? It seems like they're trying to keep prices high in order to extract surplus from the consumers. But there is, in fact, an efficiency justification for resale price maintenance, and it's as follows. Imagine you're a consumer looking to buy a Blu-ray player, and you go to Best Buy and you see there's 5 or 10 Blu-ray players there. You talk to the salesperson, ask them questions, you play around with it, push the buttons. You know, these floor models, after a few months, become pretty run down and they have to replace the floor models. In addition, they have to pay salespeople to be there to take your questions. So Best Buy is incurring costs in order to provide information to the consumers. So you go to Best Buy and you figure out, yes, I want to buy the Sony. But you see that the price is maybe $130. And you search on your phone and you find that, at Fry's, the price is lower. So why don't I just walk across the street and go to Fry's and buy it? Well, if that happens, then there may be an inefficient amount of promotional and informational services provided. In other words, eventually Best Buy is going to say, well, look, if Fry's is just going to undercut me, and I'm providing all this information to consumers, I'm just going to stop providing all the information. So then the consumers don't have enough information, and Sony is worried that the retailers aren't doing enough to promote their products. And so in fact, resale price maintenance should not be per se illegal because there could be efficiency justification for it. In other words, when the courts hear cases involving resale price maintenance, they should decide under a rule of reason. And there are many, many other examples of this. And so, well, we had been talking about the history of antitrust laws. Again, the original act was the Sherman Act of 1890. And by the way, if you studied Civil War history, you might have heard the name Sherman. William Tecumseh Sherman was a Civil War general. The Sherman Act was named after his brother, who was a senator. But there was some confusion after this act was passed. And subsequent laws, which we'll talk about next, were passed in order to resolve this confusion. So for example, sometimes mergers were illegal under the Sherman Act because they would create a monopoly. But what sometimes happened is the firms, rather than buying the company, just purchased the shares of the company. So they effectively bought it or controlled it now, but just not legally merged it. And so essentially that's a loophole that the Clayton Act of 1914, so like 24 years later, was passed to close. Another act that was passed in that same year was the FTC Act, the Federal Trade Commission Act. And this act did a number of things, including established a federal agency called the Federal Trade Commission, or the FTC. And today, the FTC, along with the Department of Justice, DOJ, are the two entities that are responsible for prosecuting antitrust lawsuits. In addition, private individuals or firms can sue another individual or firm for violation of the laws. So there are a variety of methods of enforcement of these antitrust laws. The other main act that the book discusses is the Sellar-Kefauver Act of 1950. And this did also all of these acts do a number of things, but the books just highlight some of the main ones. This one tried to block vertical mergers that might be anti-competitive. So what's a vertical merger, and how does that differ from a horizontal merger? Well, a horizontal merger is a merger between two firms that are in the same industry, that are doing the exact same thing. So like Pizza Hut and Papa John's are both selling pizzas. If they were to merge, that would be a horizontal merger. But a vertical merger is a merger between two firms that are related in the supply chain, but they're doing different things. So for example, a merger between Papa John's and the tomato sauce manufacturer would be a vertical merger. And sometimes vertical mergers can be efficiency enhancing, and so we don't want to outlaw all vertical mergers, but it's possible that in some cases they're anti-competitive, and this act provided some basis for that. Now, one aspect of antitrust law, and in fact laws, the legal area as a whole, makes it difficult to answer the question, what's illegal? So if you were to ask me, what types of activities can a firm do safely without being without worrying that they're going to get sued by someone for violating antitrust laws? And in fact, it's hard to give a straight answer for that, because the laws sometimes are vague themselves, and not only that, the interpretation of the laws by the courts has varied over time. And so some judges have applied a strict per se illegality notion to interpreting the law. And if you're doing something that the law says you can't do, you're going to be guilty. On the other hand, other judges have applied a rule of reason, and that's changed over time. And also, the precedents set by previous decisions also determine whether a business action is illegal or not. So it's very difficult to say whether something is illegal or not. And we live in this world of ambiguity. Now, in many cases, economic theory would tell us what should be legal. And the standard that economists use is that of net benefits, right? If a decision would increase net benefits, then that's the right decision. But that's not the way that the legal world works, right? The legal world looks at the laws and tries to decide based on the laws. So we've seen things change over time. There has been more openness to mergers in the last few decades than there had been, say, in the 50s and 60s. And so, in fact, it changes with the political regimes, because the president appoints judges, judges are appointed through some political process. So the judges that compose the bench also affect how these laws are decided. So it's a bit of a murky area. And some people are good at navigating murky areas. I myself am not one of those, but people who want to go into law profession need to be. Before we move on, there's one term here that it's worthwhile to mention, and that is contestable. A market can be contestable. And what that means is there may not be a large number of competitors in the market right now. But if entry is easy, then the firms in the industry today will act as though the market is competitive, because if they price above cost and are making a lot of profits, that's going to encourage entry. And so this gets back to the notion of, sometimes things are illegal if they're done in a market that is concentrated. That, in other words, there's not much competition. Whereas the same action may be illegal, may be perfectly legal, if the market is competitive. So, but what does it mean for it to be competitive? In a previous chapter, we looked at the Hirschman-Herfindahl index, and also the 4-firm concentration ratio, and so on. So these are measures of concentration, but they refer only to the existing firms in the market, not potential entrants. And that's what this term contestability refers to. If it's easy for potential entrants to come in the market, then it might be competitive, even if the concentration ratio suggests it's a concentrated industry. Recognizing that there is this ambiguity in the antitrust laws, the antitrust authorities, the FTC and the DOJ, have tried to clarify things. And one of the things that they've done is published this horizontal merger guidelines book. And so if a firm is considering merging with another firm, they might wonder, are we going to get sued for this? Is this going to be blocked or not? And all the time in the news, we hear examples of firms that are merging. Has anyone heard a recent one? For example, in the airline industry, is it United and, I don't want to misspeak, but I think it's United and American. And so those are two huge firms. Are they going to be allowed to merge? We don't know. But there are some guidelines to follow. If the Hirschman-Herfindahl index post-merger is 1,000 or less, then they're almost certainly going to be allowed to merge. But if it's greater than 1,800, then they're probably going to get sued by the FTC or the DOJ. And whether they're going to be allowed to merge or not depends on what the judge decides. So these are some guidelines. It also depends on how much the HHI increases. And let me just refresh your memory on what is the possible range of the HHI. It can go from 0 if it's perfectly competitive, all the way to 10,000 if there's one firm, a monopolist in the industry. Why? Because the market share of each firm is squared and added together. So if there's one firm, they have 100% market share, 100 squared is 10,000. But if there's a million firms, all with a tiny market, one over a millionth market share, then the HHI is going to be basically 0. Yeah, question? Mm-hmm. Yeah, that's a good example. She was mentioning the proposed merger by AT&T and T-Mobile, and I recall that vaguely. And so that's a good example. So some of them are blocked, some of them are eventually allowed. And this is something that you see all the time in the newspapers, in the business section. Now, we were talking about evaluating the concentration of an industry. And in principle, if you're given the industry, you know what firms are in this industry, that's easy to do. But there's one subtle question here, and that is, how do you define an industry? Well, I can give you another example, one that's probably before the time when most of you were paying attention, but around like 2000, 2002, there were two satellite radio companies, XM and Sirius Satellite Radio. And they proposed to merge. And so what market is that? Should we call it the market for satellite radio? Well, if so, there's only two firms in that market. So the HHI is really high, right? It's way above 1,800. If they each have 50% market share, then it's 50 squared is 2,500, I think. 25 plus 25 is 5,000. So the HHI is way above here. So this would suggest these two firms could not merge. Well, in fact, they did end up merging. Because you haven't heard about Sirius Satellite Radio probably, huh? But you have heard of XM. I think this is still in business today. And why is that? Well, the relevant market probably shouldn't be satellite radio. Because people consume music on the radio, CDs or MP3s, in a variety of ways, right? So the market is something more like recorded music or radio, perhaps. And so that's one of the big, almost always one of the controversial issues in these court cases is how do we define the market? And there are some tests, as the book explains. It basically comes down to estimating the cross-price elasticity of demand. If the price of Sirius satellite radio goes up, what happens to the quantity demanded for XM? Or if the price of a CD or some internet radio goes up, what happens? If there's a big effect, then they're in the same industry. And there are some more specific ways of delineating industries than that, but they all come down to estimating the cross-price elasticity of demand. And that's really what you need to know for this section. Well, here we have, before we close this section out, this case in point article asks, does antitrust policy help consumers? Because of course there's a cost to antitrust policy, right? The government has to pay a lot of lawyers to work on its staff. The firms have to hire lawyers in order to fight the lawsuits. So that's a cost to it. In addition, there could be other costs, like sometimes wise business moves or efficient business moves might be blocked. And so the consumers could be harmed in that way. So economists have tried to estimate, for example, what happens after an antitrust action. Does the prices fall in that industry? If so, that's good for consumers. But we may not always see that. So this is a picture of a Standard Oil refinery around 1890. Again, Standard Oil was the first company that was sued under the Sherman Act. But many other companies have since been sued under the Sherman Act, and a couple that are relevant to the main industry in our region, information technology, computers, and so on. IBM has been sued a number of times for various antitrust violations. One of them came about in 1966, but the case dragged on so long, for like 15 years, that eventually, in 1982, the case still was not resolved. The government decided to drop the case because it was totally irrelevant because that industry had been changing so fast. Similarly, Microsoft was sued around late 90s. And in 2000, they were found guilty. And the court ordered that Microsoft would have to be split into two companies. One that provided operating systems, like Windows, and one that provided applications, like Word and Excel. But Microsoft appealed, and eventually they got that reversed. But what did we see pretty soon after that? Well, Apple became, they had an increasing market share. Google eventually came onto the scene with Docs. And so now we have a lot more choice in applications and even operating systems. And so Microsoft is not the competitive threat that they were even a few years ago. And in fact, now Google is under antitrust scrutiny. So markets change so much. They're so dynamic that it's not clear whether antitrust action is fast enough to really bring about any positive change. So that's a debatable area, as are many of the things we'll talk about in this section.